Deborah Brake is the Associate Professor of Law at the University of Pittsburgh School of Law. Professor Brake is formerly employed as the National Women's Law Center, where she litigated cases challenging sex discrimination in education, employment, housing, and prisons, and worked on policy issues affecting women in Congress and administrative agencies. She is a graduate at Stanford University and Harvard Law.
Chairman Miller, Ranking Member McKeon, and members of the committee, I thank you for the opportunity to discuss the problems created by the Ledbetter decision. My reasons for urging Congress to overturn this decision are detailed in my written testimony, and I will highlight some of them in my time before you today. First, the Court's decision can only exacerbate the gender wage gap. By categorizing pay decisions as discrete, the Court's ruling is blind to the realities of pay discrimination. Discriminatory pay decisions are not separate and distinct from the paychecks that follow. Left uncorrected, even a relatively minor disparity will expand exponentially over the course of a career. To illustrate, a study by researchers at Carnegie Mellon University gives the example of a 22-year-old man earning a starting salary of $30,000 and an equally qualified 22-year-old woman earning $25,000. Assuming each receives a 3% annual raise, this $5,000 gap would widen to $15,000 by the time the workers reached age 60, with a total pay difference of over $360,000 over their employment lives. If the man earned 3% annual interest on the difference, the disparity would total a staggering $568,000, enough to fund a secure retirement or a college education for several children. Under the Ledbetter rule, the young woman in this example must bring a Title VII claim within 180 days of when the initial discriminatory pay decision was made and communicated. Failing that, Title VII provides no legal recourse. As Justice Ginsburg recognized, the effect of the Court's decision is to render such discriminatory pay decisions, quote, grandfathered, a fait accompli beyond the province of Title VII ever to repair. The implications of the Court's ruling for the gender wage gap are stark. Second, employees are not likely to be able to challenge decisions within the time frame allowed. It is very difficult to know if you have experienced pay discrimination. People rarely know what their colleagues earn, much less what raises are received at each and every salary review. At least with hiring, firing, promotion, and demotion decisions, the affected employee knows she has experienced an adverse action. She can search out an explanation, evaluate it for pretext, observe any comments suggestive of bias, and easily identify comparators. Pay decisions, in contrast, are rarely accompanied by an explanation from the employer comparing salaries. And unlike job decisions such as hiring and promotions, where an employee can get some picture of how women fare generally in such decisions, a typical employee has no way of knowing how women overall are paid in comparison to men. Often, women's pay starts out even with men, but gradually and almost imperceptibly declines over time in relation to men's. These women are likely to find their Title VII claims foreclosed. Even if an employee is aware of a modest discrepancy, a relatively minor disparity is likely to go unquestioned for some time until it becomes too large to ignore. Women who are subjected to pay discrimination at the time they are hired face their own set of difficulties. A new employee is unlikely to have the kind of connections necessary to find out about pay discrimination or the kind of support and established work record it takes to have the courage to challenge it. Fourth, employers do not need the protection of the Ledbetter rule. There are already strong incentives on employees not to delay filing. First, the employee has the burden of proof, and it is the employee who is likely to be disadvantaged by delay. If the jury can't figure out what happened because the evidence is stale and memories have faded, the employee loses. Second, plaintiffs who engage in unreasonable delay in filing are barred from doing so by the defense of laches. Third, since employees may only recover back pay for a maximum of 2 years prior to filing the EEOC charge, they have a strong incentive to quickly challenge pay discrimination that has gone on for more than 2 years because the employer can keep the windfall from any discriminatory pay that falls out of that 2-year limit. Only the employer is in a position to know about and evaluate disparities in salaries. But under the Court's ruling, employers have no incentive to proactively examine pay equity, and they get a virtual pass to continue pay discrimination that is older than 180 days. In the long run, even employers are not well served by the Ledbetter rule. The ruling encourages hypervigilance on the part of employees, a formal adversarial approach to the slightest pay discrepancy, and a concerted effort to search out information about the salaries and raises of their colleagues, not a recipe for a collegial workplace or a high level of trust between management and employees. Until the Ledbetter case, lower courts across the country, as well as the EEOC, had allowed employees to challenge discriminatory paychecks received within the limitations period. I urge Congress to restore the paycheck accrual rule that was widely understood to be the correct interpretation of Title VII until the Supreme Court just recently opted for a different course.